I just had a couple of questions. One was why the coal combustion residuals disposal units were removed as it related to the TDEC's oversight, it seems.
Chairman Todd.
Thank you, Mr. Speaker. This sets up a framework necessary for TDEC to develop a state coal combustion residual landfill permit program. So they're setting up a program to submit to the EPA for approval to return regulatory authority over all of these landfills. The permit program is a response to the Kingston Coal Ash Spill of 2008 and was later promulgated in rule by the EPA in 2015, requiring each state to either create their own CCR permit program or cede regulatory primacy to the EPA to run this permit program in the state. And I think if anybody has ever dealt with EPA and or TDEC, they know that we would much prefer our own department to deal with our citizens rather than have federal folks in our backyards working on our programs.
Representative Pearson.
Okay, thank you for that explanation, sponsor. And because of the amount of places across our country that I think are dealing with this issue as it relates to coal ash, from West Virginia through Appalachia, right, into Tennessee, into my district in particular, I do think having a framework within our state is something that's useful and important, but I don't know if it is necessary sort of to take this step where we're not listening at all or not having to follow the guidance or guidelines of the EPA, which is changing drastically, right? So I can understand and appreciate this. And I do believe TDEC, and again, this happened with us, TDEC was involved in making sure that there was some coal ash remediation. So I don't want them to cede power either in the places that they do have it, nor allow for the EPA guidance that they're giving to be ignored. And so that's the tension that I have with your legislation.
Chairman Todd.
Thank you, Mr. Speaker. And I think this accomplishes what you're talking about. I really do. This keeps this program under state control, but it's under the EPA minimums. And a lot of times our state regulations even exceed what EPA requires. And so that keeps it under even our control, so that if you have an individual problem in your district, you see a problem or have folks that are dealing with complaints that may not be dealt with properly on the state level, then we know who to call. We can press that button. Whereas if it's EPA, it's much more likely that you'll get ignored instead of getting something done. So I think this keeps that control in our state house where it should be and closer to us, which are closer to the people.
Representative Pearson. Very good. Representative Fritz.
Thank you, Mr. Speaker, and thank you for bringing this bill, sponsor. Very familiar and respectfully, my colleague from West Tennessee. I do think your bill is going to help us deal with things. We did have some issues of mismanagement with that coal ash spill. It's a tremendously horrible thing for lots of folks in the Roane County area. But I do think this is going to help by keeping control at home and making sure that we can use that fly ash for all the good purposes that it can be used for, and make sure we can disposition it quickly. So I do think you're helping with that situation. Thank you so much.
Chairman Todd. Very good. Representative Travis.
Thank you, Mr. Speaker. Move previous question.
Appreciate the call. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 1274 vote aye when the bell rings. Those opposed vote no. As every member vote, as any member wish to change their vote. Mr. Clerk, please take the vote.
Aye, 73, 23 nays.
Senate Bill 1274, having received a constitutional majority, everybody clerk passed without objection. The most reeks here table. Call up next bill, Mr. Clerk.
House Bill 142 by Representative McCalman relative to alcoholic beverages. Mr. Speaker, Senate bills on the desk.
Representative McCalman, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to SB 111.
Representative McCalman moves substitute and conform Senate Bill 111 without objection. So ordered. Representative McCalman.
Thank you, Mr. Speaker. I move passage of Senate Bill 111 on third and final consideration.
Representative McCalman moves passage of Senate Bill 111 on third and final consideration. By second. Mr. Clerk, call first amendment.
Mr. Speaker, no amendments filed.
Representative McCalman, you're recognized.
Thank you, Mr. Speaker. Members, what Senate Bill 111 does is simply say that if you are the owner of a winery and a distillery and both are on the same property, you don't have to have two separate tasting rooms. You could have a tasting room for both your distilled spirits and your winery in the same place. And with that, I stand ready for any questions and renew my motion, Mr. Speaker.
Representative McCollum renews his motion. Any discussion on the bill? Oh, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 111 vote aye when the bell rings. All those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 76, 15 nays, 4 present, not voting.
Senate Bill 111, having received a constitutional majority, I hereby declare passed without objection. Motion reconsider table. Call up next bill, Mr. Clerk.
House Bill 318 by Chairman Rudd and others relative to state government. Mr. Speaker, Senate bills on the desk.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. I move substitute and conform to Senate Bill 0263.
Chairman Rudd moves substitute and form Senate Bill 263 without objection. So ordered. Chairman Rudd.
Thank you, Mr. Speaker. I move passage of Senate Bill 0263 on third and final considerations.
Chairman Rudd moves passage of Senate Bill 263 on third and final consideration. Properly second. Ms. Clerk, call up First Amendment.
House Amendment 1 by Representative Salinas, Mr. Speaker, was not timely filed.
Representative Salinas, you're recognized.
Thank you, Mr. Speaker. My amendment would rename this bill the Anti-Public Health Initiative Bill. I think it's important that we remember that we belong to each other and that our community health is important, and this bill would have a negative consequences on the health of our community. The WHO does not issue mandates, they only issue recommendations. And when we attack health agencies that are set up to promote public health, it really hurts our community and it devalues these vital organizations. And I know that this bill is a dog whistle and it's talking points for future campaigns, but as a scientist that has worked along the WHO, I think it's important that we recognize that the WHO does important work and that we trust the scientists that work at the WHO. As we face the threats of malaria and other infectious diseases, it's important that we...
I'm assuming she was trying to move for consideration. You heard the motion properly seconded. We're voting for consideration of amendment number 1. All those in favor of considering amendment number 1, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Darby, no. Ms. Clerk, please take the vote.
Ayes 25, 71 nays.
In accordance with Rule 60B, having failed to receive the necessary 2/3 vote, the motion to consider amendment number 1 fails. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. What this bill does, it simply states, the legislation states that any policy of the World Health Organization, the United Nations, or the World Economic Forum have no jurisdiction in Tennessee. The previous administration attempted to implement some of the policies of these organizations on vaccinations and climate change by policy of departments. And we're simply stating that unless it's passed by Congress, it has no jurisdiction here. No foreign entity, no foreign or governmental entity should have any jurisdiction in the United States or Tennessee without congressional or legislative approval. And with that, Mr. Speaker, I renew my motion.
Chairman Rudd renews motion. Any discussion on the bill? Representative Travis, you're recognized.
Thank you, Mr. Speaker. Move previous question.
Previous question been called. Is there objection? We're on the board. All those in favor of previous question, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please. Cochran, aye. Mr. Clerk, please take the vote.
Ayes 73, 24 nays.
Previous question prevails. So we're voting. All those in favor of Senate Bill 263, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Yeah, you got it. Mr. Clerk, please take the vote.
Ayes 72, 25 nays.
Senate Bill 263, having received the constitutional majority, hereby declare passed without objection. Most reconsider table. Call up next bill, Mr. Clerk.
Senate Joint Resolution 1 by Chairman Darby.
Chairman Darby, you're recognized.
Mr. Speaker, I request that the clerk read SJR 1 for its second reading.
Mr. Clerk, please read the resolution.
Senate Joint Resolution 1 on second reading. A resolution to propose an amendment to Article 2, Section 28 of the Constitution of Tennessee to prohibit taxation of property by the state. Whereas House Joint Resolution number 81 of the 113th General Assembly, which proposed amendment to Article 2, Section 28 of the Constitution of Tennessee, was considered and agreed upon by a majority of all the members elected to each of the two houses, as shown by the yeas and nays entered on their journals. And whereas such resolution proposing such amendment was published in accordance with Article 11, Section 3 of the Constitution of Tennessee, and whereas Article 2, Section 28 of the Constitution of Tennessee currently authorizes taxation of all property according to its value by any taxing authority, including the state, counties, and municipalities. And whereas the state can impose a property tax, as it did until 1949, to all property in the state, and whereas in 1949, the legislature repealed the state's property tax, and whereas the current property tax is imposed at the local level at various county and municipal tax rates, and whereas the controlling and predominant purpose of the property tax is for local purposes, now therefore be it resolved by the Senate of the 114th General Assembly of the state of Tennessee, the House of Representatives concurring, that a 2/3 majority of all the members of each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 2, Section 28 of the Constitution of the state of Tennessee be amended by deleting the following language from the first sentence. In accordance with the following provisions, all property, real, personal, or mixed, shall be subject to taxation, but the legislature, and substituting instead the following. In accordance with the following provisions, all property, real, personal, or mixed, shall be subject to taxation, but the legislature shall not levy, authorize, or otherwise permit any state tax upon such property, and the legislature. Be it further resolved that in accordance with Article 11, Section 3 of the Constitution of Tennessee, the foregoing proposed amendment shall be submitted to the people at the next general election in which a governor is to be chosen, the same being the 2026 November general election, and the Secretary of State is directed to place such proposed amendment on the ballot for that election. Be it further resolved that the clerk of the Senate is directed to deliver a copy of this resolution to the Secretary of State with this final resolving clause being deleted from such copy.
Representative Darby, you recognized.
Thank you, Mr. Speaker. I move that SJR 1 be set for its third and final reading on Monday, April the 21st of 2025.
Without objection, so ordered. Next bill, Mr. Clerk.
SJR 9 by Chairman Doggett.
Chairman Doggett, you're recognized.
Thank you, Mr. Speaker. I request the clerk read Senate Joint Resolution 9 on its second reading.
Mr. Clerk, please read the resolution.
Senate Joint Resolution 9 as amended by the Senate on second reading. A resolution proposing an amendment to Article 1, Section 35 of the Constitution of Tennessee relative to the rights of crime victims. Whereas House Joint Resolution number 94 of the 113th General Assembly, which proposed amendment of Article 1, Section 35 of the Constitution of Tennessee relative to the rights of crime victims was considered and agreed to by a majority of all the members elected to each of the two houses, as shown by the yeas and nays entered on their journals. And whereas such resolution proposing such amendment was published in compliance with Article 11, Section 3 of the Constitution of Tennessee, now therefore be it resolved by the Senate of the 114th General Assembly of the state of Tennessee, the House of Representatives concurring, that a 2/3 majority of all members of each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 1, Section 35 of the Constitution of Tennessee be amended by deleting the section in its entirety and substituting the following. Section 35, that to preserve and protect the rights of victims of crime to justice and due process throughout the criminal and juvenile justice systems, a victim, as defined by law, and which may be expanded by the General Assembly shall have the following rights which shall be protected. 1, the right to be treated with fairness for the victim's safety and dignity. 2, the right upon request to reasonable notice of all public criminal proceedings and all public juvenile delinquency proceedings involving the accused. 3, the right to be present at all public criminal proceedings and all public juvenile delinquency proceedings involving the accused. 4, the right upon request to be heard in any proceeding involving release, plea, sentencing, disposition, and parole, as well as any public proceeding when relevant during which a right of the victim is implicated. 5, the right to be heard and informed of all parole procedures, to participate in the parole process, to provide information to the parole authority to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. 6, the right to be free from harassment, intimidation, and abuse throughout the criminal justice system, including reasonable protection as defined by the General Assembly from the accused or any person acting on behalf of the accused. 7, the right upon request to reasonable notice of any release, transfer, or escape of the accused or convicted person. 8, the right to full and timely restitution from the offender. 9, the right to a speedy trial or disposition and a prompt and final conclusion of the case after the conviction or sentence. 10, the right to be informed of the minimum sentence the offender will serve in custody and the scheduled release date. 11, the right to have the safety of the victim, the victim's family, and the general public considered before any parole or other post-judgment release decision is made. 12, the right upon request to confer with the prosecution. And 13, the right to be fully informed of all rights afforded to crime victims. A victim may assert the rights enumerated in this section, not as a party, but in the manner further provided by the General Assembly, protecting the victim's right to standing. The General Assembly has the authority to enact substantive and procedural laws to further define, implement, preserve, and protect the rights guaranteed to victims by this section. This section must be interpreted to preserve and protect the rights of all persons to due process. This section, or any law enacted under this section, does not create a basis for vacating a conviction. This section does not restrict the powers of the District Attorney General or the inherent authority of the court. Other than as provided in the preceding paragraph, this section does not create a cause of action or claim for damages against the state or a political subdivision of the state, an officer, employee, or agent of the state, or of any of its political subdivisions, or an officer or employee of the court. Be it further resolved that in accordance with Article 11, Section 3 of the Constitution of Tennessee, the foregoing proposed amendment shall be submitted to the people at the next general election in which a governor is to be chosen, the same being the 2026 November general election, and the Secretary of State is directed to place such proposed amendment on the ballot for that election. Be it further resolved that the clerk of the Senate is directed to deliver copies of this resolution to the Secretary of State, with this final resolving clause being deleted from such copies.
Chairman Doggett, you're recognized.
Thank you, Mr. Speaker. I move that Senate Joint 9 be set for its third and final reading on Monday, April the 21st, 2025.
Without objection, so ordered. Call up next bill, Mr. Clerk.
Senate Joint Resolution 25 by Chairman Howell.
Chairman Howell, you're recognized.
Thank you, Mr. Speaker. I request that the clerk read SJR 25 for its second reading.
Mr. Clerk, please read the resolution when you're ready.
Senate Joint Resolution 25 on second reading. A resolution to propose an amendment to Article 1, Section 15 of the Constitution of Tennessee relative to bail. Whereas Senate Joint Resolution number 919 of the 113th General Assembly, which proposed amendment of Article 1, Section 15 of the Constitution of Tennessee relative to bail, was considered and agreed to by a majority of all the members elected to each of the two houses as shown by the yeas and nays entered on their journals. And whereas on April 23rd, 2024, such resolution proposing such amendment was published in compliance with Article 11, Section 3 of the Constitution of Tennessee, now therefore be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, that a 2/3 majority of all the members elected to each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 1, Section 15 of the Constitution of Tennessee be amended by deleting the following: that all prisoners shall be bailable by sufficient sureties unless for capital offenses when the proof is evident or the presumption great. And the privilege of the writ of habeas corpus shall not be suspended unless when in case of rebellion or invasion, the General Assembly shall declare the public safety requires it, and substituting instead the following. A, all prisoners shall be bailable by sufficient sureties unless for the following when the proof is evident or the presumption great. 1, a capital offense. 2, an act of terrorism. 3, second-degree murder. 4, aggravated rape of a child. 5, aggravated rape. 6, grave torture. And 7, any other offense for which, as of November 3rd, 2026, a defendant, if convicted, could not be released prior to the expiration of at least 85% of the entire sentence imposed. B, in any case in which bail for an offense listed in subsection A is granted or denied before conviction, the judge or magistrate shall place in the record the judge's or magistrate's reasons for granting or denying bail. C, the privilege of the writ of habeas corpus shall not be suspended unless, when in case of rebellion or invasion, the General Assembly shall declare the public safety requires it. Be it further resolved that in accordance with Article 11, Section 3 of the Constitution of Tennessee, the foregoing proposed amendment shall be submitted to the people at the next general election in which a governor is to be chosen, the same being the 2026 November general election, and the Secretary of State is directed to place such proposed amendment on the ballot for that election. Be it further resolved that the clerk of the Senate is directed to deliver copies of this resolution to the Secretary of State, with this final resolving clause being deleted from such copies.
Chairman Howell, you recognize.
Thank you, Mr. Speaker. I move that SJR 25 be set for its third and final reading on Monday, April 21st, 2025.
Without objection, so ordered. Next bill, Mr. Clerk.
House Bill 923 by Representative Mayberry relative to the Dismantling DEI Departments Act.
Representative Mayberry, you recognize. At your desk.
Thank you, Mr. Speaker. I ask that House Bill 923 get rolled to today, the end of today's calendar.
Without objection, rolled to the end of today's calendar. A little late. Next bill, Mr. Clerk.
House Bill 25 by Chairman Sapiki relative to interscholastic athletics. Mr. Speaker, the Senate bill's on the desk.
Chairman Spicky, you recognize.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 16.
Chairman Spicky moves substitute and conform Senate Bill 16. Probably seconded. Without objection, so ordered. Chairman Spicky.
Thank you, Mr. Speaker. I move passage of Senate Bill 16 on third and final consideration.
Chairman Spicky moves passage of Senate Bill 16 on third and final consideration. Probably seconded. Mr. Clerk, call up First Amendment.
House Education Committee Amendment number 1.
Chairman White, you're recognized.
Thank you, Mr. Speaker. I move to adopt.
Chairman White moves adoption committee amendment number 1. Probably seconded. Any discussion on the amendment? Seeing none. All those in favor of adopting committee amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
House Amendment 2 by Representative Pearson. Mr. Speaker, was not timely filed.
Representative Pearson, you're recognized.
Thank you, Speaker. And I actually had the superintendent of Millington Public Schools reach out to me and some of my other colleagues with concerns about this legislation. This is a little bit more rural of an area in our community, but they are deeply concerned that this would have a significant impact on SSAA and having a lot of students who are going to be transferring from our schools to another school. And we're going to see a replication of some of the problems that we're seeing already at colleges and universities. And so he asked that we not support this legislation and that it might get some more work. And so for that reason, I won't be able to support it. But this amendment would take away the ability of someone to transfer as it's currently stated in this legislation. And also, it wouldn't allow for us to prevent people from using money and resources to stay within their current association. And so with that, I move for consideration.
You've heard the motion, probably second. We're voting for consideration of amendment number 2. All those in favor of considering amendment number 2, vote aye when the bell rings. Those opposed, vote no. As every member vote, as the member wishes to change their vote. Mr. Clerk, please take the vote.
Ayes 28, 65
In
nays.
accordance with Rule 60B, having failed to receive the necessary 2/3 vote, the motion to consider amendment number 2 fails. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Spicky, you're recognized.
Thank you, Mr. Speaker. Members, I'll be as brief as I can here. I'm standing here today because of a journey that I've taken with TSSAA over the last 3.5 months. I filed this legislation back in November, and when I did, it was to help our athletes who are in part of the possible school choice bill that we're going to pass in January, to have the opportunity to be able to transfer and still maintain their athletic eligibility and not have to give up 25% of their athletic career. When I presented this bill to TSSAA, I had meetings with them, and they had an executive meeting coming up in December. And in December, they asked me to hold off on filing this legislation because they wanted to be able to take care of this in December. And then shortly before the meeting, I got a call from TSSAA executive director and their attorney and said, you know what, please file this bill because we need to use this to get our executive committee to postpone their vote in December until February. So I filed the bill in trust with TSSAA that they're working in good faith with me. We rolled to January. We're getting in special session, and I was going to run this amendment to allow one-time transfer on the school choice bill. We were coming into session on Monday. I got a phone call once again from the director of TSSAA and their attorney saying, hey, Scott, please don't run that amendment on school choice. We'll take care of this at our February meeting, not a problem. Once again, I trust TSSAA leaders again, and once again, they were untruthful with me. In February at their legislative council member meeting, they debated this issue for over 3 hours about how this was the wrong thing to do to allow a one-time transfer. And after 3 hours, they voted down their resolution 13-1. I ran the bill in subcommittee. We passed it in subcommittee. They immediately come back in March at their executive council meeting. They once again argue against a one-time transfer for 3 hours. And then they pass it 8-5. And the very next day, I get a phone call from TSSAA saying, Scott, we've passed one-time transfer, withdraw your bill. I've been up here for 7 years with you. I'm not that naive. This bill is about protecting our student athletes, especially those that take advantage of school choice, because without this legislation, they'd be ineligible for 25% of their athletic career. Can you imagine telling your kid that they have to give up 25% of whatever they do? Now, TSSAA has allowed a one-time transfer. In the language of the bill, it copies their language verbatim. The second thing they asked us to do is to make sure we don't wind up like Florida, Texas, and California, where these athletes are transferring throughout the year. And so we put another amendment on it that said, if you do transfer under this provision, you have to do it before the start of the school year. And then they argued that it's going to cause us undue lawsuits, that we're going to get sued as TSSAA and it's going to destroy it. So I had a conversation with the Attorney General. And we put another amendment on the bill that says there is no private right of action against TSSAA because all we're doing, ladies and gentlemen, is just agreeing with them. Now, I've been asked by many members up here to pause this bill. They don't want to take this vote this year. I get it. TSSAA has moved in 2 months what they've tried to do in 3 years, and I wonder why. I wonder why they finally decided to stick up for their student athletes. It could be because of the piece of paper sitting here before you. But out of respect for members here and the movement that they've made, I want to make sure that we're able to watch them for the next year. And when we come back here next year, if they have monkeyed with this thing to hurt our athletes, I'm going to ask for your support next year that we come back and we tell TSSAA, no, the General Assembly is going to stand with their athletes and make sure that they give them the opportunity that they're entitled to. So with that, Mr. Speaker, I ask that this bill be moved to the first available caliber in February of 2026.
You don't want January? Without objection, first calendar of February 2026. Call up next bill, Mr.
House Bill 622 by Representative Mayberry relative to hiring practices of governmental entities.
Representative Mayberry, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 622 on third and final consideration.
Representative Mayberry moves passage, probably second. Mr. Clerk, call it First Amendment. Parliamentary inquiry. Something. Thank you. Mr. Clark.
Mr. Speaker, the question was, what is the appropriate procedure to challenging a fiscal note for legislation that's on the House floor? The House rules do not speak to challenging what is in the fiscal note on the House floor. That is not to say that a member could, if they thought there should be more concerns about the fiscal note, that they could not make a motion to have a bill re-referred to finance for that purpose. Is there a procedural mechanism or rule to challenge the fiscal note at this time? There's not a mechanism to challenge that while we're on the House floor. However, as I stated before, a motion could be made to re-refer that bill to finance. Fiscal review does have an appeal process. And the third question was, could this body, if this bill passes today, recall this bill from the Senate and reconsider their actions in order to initiate that fiscal review appeal process? The answer is yes. This body could make a motion, if this bill passes, to recall it from the Senate. If the Senate chose to send it back to the House, then the House could reconsider their actions after the bill was passed.
Very nice. Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. This amendment rewrites the bill. I move to adopt and defer the sponsor for further explanation.
Chairman Crawford moves adoption committee amendment number 1. Probably second. Any discussion on the amendment? Seeing none. All those in favor of amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
House Education Committee Amendment number 1 filed as House Amendment 2.
Chairman White, you're recognized.
Thank you, Mr. Speaker. I move to adopt.
Chairman White moves adoption committee amendment number 2. Probably second. Any discussion on amendment? Seeing none. All those in favor of committee amendment number 2 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
House Amendment 3 by Representative Jones and Davison. Mr. Speaker, was timely filed.
Representative Jones Davison, you're recognized.
Thank you, Mr. Speaker. Wake up, wake up. We want freedom, freedom. All these racist policies, we don't need them, need them. This bill from Representative Mayberry is using coded language of DEI, because you won't say the word of diversity, equity, inclusion. What are you against, my brother? But it's really what he's against is racial progress of the civil rights movement, because he's afraid to use the word black, who he's attacking, and chose to come here and introduce these racist, vile, unnecessary bills to wage culture wars and target marginalized groups of people, and it's shameful. This bill is not necessary, Representative Marbury, which is why the people of your county, Montgomery County, have showed up to your office week after week opposing this bill. This bill is about undoing the progress made in the civil rights movement and taking us back to a time where people like me could not even serve in this chamber. It's shameful. And I hope that people here see what is really going on. Is that Tennesseans, they have not done anything to make your lives better with living wages or health care. And so they have to wage these false wars to make you feel like they're fighting for you, because they are not actually doing the people's business. There's nothing in this bill that will make your life better. Let me tell you why we need DEI. Just last year in Hamilton County, the Hamilton County, Tennessee School District had to reach a settlement with the U.S. Department of Justice after a federal investigation found evidence of racial harassment where a black student was called racial slurs and sold to fellow white students in a mock slave auction. This is Hawkins County. The district was told that they were deliberately indifferent to known race-biased harassment at schools by the Department of Justice. The Justice Department investigation found that white students repeatedly used the N-word and held a, quote, Monkey of the Month campaign to ridicule black students. Again, this is in Hawkins County, not in 1964, but in 2024. Under the settlement, Hawkins County School District had to undertake reforms, including hiring new staff to handle complaints of racism, teacher training, and processes to inform students and parents on how to report racist harassment. This is why we need DEI, representative from Hawkins County, because in your county, black students made their complaints known to the school district, and those officials were racially insensitive. The Department of Justice had to intervene, and your county, representative from Hawkins County, had to reach a settlement with the Department of Justice because they were not addressing the harassment, the hostile environment for black students.
Representative Jones, you're on your amendment. You've gone about 2.5 minutes and haven't even spoken of your amendment. We're on the amendment number 3. If you like to discuss amendment number 3 and how it deals with the bill, please do, or we can move on and take up or not take up Amendment 3. So please stay on Amendment number 3. Representative Jones, you recognize.
This amendment is about renaming this bill for what it is: the Dismantle Civil Rights Act. That's what Representative Mayberry is trying to do here in 2025. He's trying to turn back the clock of history and bring us back to a time we don't want to go to. These students in this county deserve better. They deserve faculty and staff who are sensitive, who are aware, who are conscious of racial bias, who understand that diversity, equity, inclusion, let's keep saying the word because he doesn't want to say it, are necessary to our vision of multiracial democracy. We did not bring this bill. Your side of the aisle brought this bill to engage in this debate, in this attack that is trying to target Black students, Black people, Black employees in Tennessee, and it's wrong. When I read this story, this is one of many stories. One of many stories in Tennessee where we've had to have interventions because of racially hostile environments created by conversations like this in this body that seek to demonize DEI as being somehow anti-American or unnecessary, when still to this day, even in this chamber, we see the need for diversity, equity, and inclusion. When that sponsor held up a whip just a few days ago, didn't understand what that meant, but we know what it means. When we walk into a building built by the enslaved, when we see pictures and the arrogance and the hubris and the attacks on Black people day after day after day in this chamber, it's unnecessary, Representative Mayberry, and I hope you do the right thing as a Christian during this Holy Week. Tomorrow's Good Friday. Let's learn to show that we're Christian by our love, not by our hate. Don't be like those who burn crosses to show their religion. Be like those who said we're going to build a multiracial vision of what America ought to be. Let's work together. So you can't go to church on Sunday and preach about we love each other and Jesus loved us, and then come in here on Monday and on Thursday and attack your fellow brothers and sisters who are Black and brown in this state. That's not the Christianity that we espouse. Lay down the burden of racism, Brother Mayberry. Lay down the burden of hatred and bigotry, Brother Mayberry. Lay down that burden and rise up anew. Be somebody worthy that your children can be proud of. Don't walk in here with this shameful legislation, Brother Mayberry. Do better, brother. I move.
I got you. That's a proper motion, probably seconded. We're moving for adoption of Amendment number 3. Chairman Sapiki, you're recognized.
Mr. Speaker, move previous question.
Previous question's been called. We're voting on Amendment 3. Any objection? You are objecting to your own amendment. All right. We're on previous question. All those in favor of previous question, vote aye on previous question. All those opposed to previous question, vote no. If you're for previous question, vote aye. If you're against previous question, vote no. Mr. Clerk, please take the vote.
Aye, 70-22 nays.
Previous question prevails. We're voting on amendment number 3. All those in favor of adopting amendment number 3, vote aye when the bell rings. Those opposed, vote no. Mr. Clerk, please take the vote.
Ayes 23, 72 nays.
Amendment number 3 fails. Next amendment, Mr. Clerk.
Amendment 4 by Representative Johnson, Mr. Speaker, was timely filed.
Representative Johnson, you're recognized.
Thank you, Mr. Speaker. What this bill does is rename this bill the White Fragility Act. I do not understand why 3 words that have been positive words, positive concepts for 60 of my 62 years, everyone on this floor would have thought diversity, equity, and inclusion were positive words and positive concepts. I'm sorry that some of us in this room may need a dictionary, But the reality is, a lot of folks in this room think that DEI is the same thing as affirmative action. It absolutely is not. With diversity, equity, and inclusion, we do have some interest in who we recruit and who we hire, because certainly organizations that serve the entire state of Tennessee or the entire public want their employees to look like that public. And then what DEI is, for the most part, is making sure that everybody that's working there feels respected and part of the team. So it's how do we go about making those people feel respected? Why are you all so afraid of making sure that every person of every race, of every religion, the disabled, women, veterans, why are you doing everything you can to complicate the relationships in the workplace? Every company in this country that has strong DEI policies, they are thriving. They have a healthy workplace. They have happy employees. They spend less time training employees because everyone feels respected. They actually take time to make sure that everyone feels respected. I don't know what your problem is with people being treated like actual human beings on the job. I think you should do some introspection and find out why it is you want to make sure some people don't feel comfortable on the job. That seems like a problem to me. But let me explain to you what the problems we're having right now at the federal level. We have no idea. This comes from somebody dealing with it right now. We have no idea how this will be carried out. It's causing confusion at the federal level. Can we celebrate historic gains by minorities in our field by posting about them on our web pages? Can I get a summer intern that I have requested through a program to benefit minorities from our field? No. The answer was no. Everyone is on equal footing. Well, except people with no feet, like veterans that got blown up in Iraq. But now we have to ignore that and make them come to the office full time, regardless of PTSD, accessible desks, or anything else. We are told there's a legal requirement to provide accessible work options, but then we are told we can't address accessibility. We are hurting all kinds of folks. We're actually hurting the majority of folks, because when we talk about the racism in this legislation, it's hurting Black and brown folks and other races for sure, but it's also hurting women and the disabled and veterans. Are you all so terrified of people that don't look like you and believe like you that you want to make sure that you're the ones in charge? Well, my friends, there is a word for that, and it's not a good one. Think about what you're doing. This bill is racist. It's sexist. It's ableist. It's religious discrimination as well. So there's a whole lot of discrimination in this bill. Move for consideration for the white.
Representative, well, it's actually, I think it's adoption, not consideration, but Representative Johnson moves adoption of amendment number 4. That's properly seconded. Any discussion on the amendment? Chairman Todd, you're recognized.
Thank you, Mr. Speaker. I move previous question on the amendment and the bill.
That's the proper motion, probably seconded. There's objection. There's a parliamentary question. Parliamentary question. Parliamentary question. Parliamentary question. I got you. Yeah, that's what I'm saying. Mr. Clerk.
Mr. Speaker, the parliamentary inquiry is it allowable for a member to call the question on the amendment and the bill at the same time? Rule 36, the previous question shall only be admitted when demanded by 2/3 of the members present. It may be applied to the main question and amendment, or to the main question and amendment to the amendment. If it prevails, the effect shall be to preclude all future amendments and terminate all debate.
Representative? Representative Darden, you have a parliamentary situation? We got another one. Hang on. All right,
Mr. Speaker, there is a question about the voting procedure on this motion as it has been proposed on the amendment and the bill. There is objection to previous question. So there'll be a vote on previous question. If it gets 2/3 of the members present, previous question will prevail. The body will then proceed to immediately vote on Amendment 4. And after that vote is disposed of, the body will immediately vote on the bill.
Representative Leatherwood, did you have one too, or did that take care of it? No. I'm sorry, that's not how you do it, Representative. You know that. Representative Pearson, you have, Pearson's first. Representative Powell, Pearson's been recognized, sir. Pearson. No, Representative Pearson is recognized. Representative Powell, please step away, please. Thank you. Representative Pearson. Representative Pearson, let me remind you, we're in session. And the rules still pertain. I don't hear anything. I'm not saying either one of you. I'm just saying, I'm reminding you both, we're in session. Is that okay? Reminding both in session. All right. Representative Powell. Mr. Clerk.
Mr. Speaker, further question is, does the member have to remain in the well while we are on their bill going through debate on the amendments? Our rules do not require a member to be in the well while we're on the bill.
All right, Leader Camper. All right, Mr. Clerk, so let's remind the body where we're at.
Mr. Speaker, the parliamentary situation is that Representative Mayberry has moved passage of House Bill 622. Representative Johnson has moved adoption of amendment number 4. Chairman Todd has moved previous question on the amendment and the bill. We will now vote on previous question. If previous question prevails, the body will immediately vote on amendment 4 and then proceed to immediately vote on the bill itself.
All right, we're on the board for previous question. All those in favor of previous question, vote aye when the bell rings. Those opposed, vote no. Mr. Clerk, please take the vote.
Aye, 68, 24 nays.
Previous question prevails. We're voting on amendment number 4. All those in favor of amendment number 4, vote aye when the bell rings. Those opposed, vote no. Mr. Clerk, please take the vote.
Ayes 24, 71 nays.
Amendment number 4 fails. We are voting. Let's see. On Senate Bill 1083. I'm sorry, House Bill 622. All right, you have to come forward. We don't do it from the desk. All right, we're voting. All those in favor of House Bill 622 as amended, vote aye when the bell rings. Those opposed, vote no. As every member voted, does anyone wish to change their vote? Mr. Clerk, please take the vote.
Ayes 73, nays 24.
House Bill 622, having received constitutional majority, everybody declare it passed. I object to the motion to reconsider is tabled. Leader Camper, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, I move that Rule 42 be suspended and that each caucus.
49.
49, sorry. I move that Rule 49 be suspended and that each caucus be allowed 30 minutes each in debate on House Bill 923.
Proper motion by accepting the objections ordered. All right. Leader Lambert.
Thank you, Mr. Speaker. Move that the House stand in recess until 10 a.m. on Monday morning.
Without objection. All right, we'll go on the board for that. Yeah, Mr. Clerk, you want to make an announcement?
Mr. Speaker, before the body votes on this recess motion, a reminder that Finance Sub will meet immediately following in Room 1, Finance Full immediately following Finance Sub, and Calendar Rules immediately following Finance Full.
All right, we're voting on recess. We're voting in recess until Monday morning at 10 a.m. All those in favor, vote aye when the bell rings. Those opposed, vote no. Mr. Clerk, please take the vote.
Ayes 79, 15 nays, 2 present, not voting.
We're in recess till Monday morning, 10 a.m.